Okay. We thank you, Heavenly Father, for allowing us to meet here today. Please open up our minds and our hearts to this law, because all of the law is your law. We ask this through your Son, Yahushua. Okay. Go ahead, John.
Yeah, I have an announcement to make. Last Friday I made a statement that I had to go to court on Friday. Actually, I'm so confused. I had paperwork to file Friday, and now my court date is tomorrow. It's in downtown Cleveland at the Justice Center, 3rd floor, courtroom 3B, 9 o'clock in the morning. And like I say, please keep me in your prayers. Thank you.
Okay, John, we will.
Hi, everyone. I'm assuming this is a private meeting and no one's here in their public capacity. Is that correct? Okay.
Yeah, we all signed in. Did I sign in? I'm here in a public capacity. What do you think mails the things? You're right, I have no capacity. Absolutely. Go ahead, I'm sorry.
Joni and Richard send their love and their appreciation for everything you've done. And they also send hurrahs and keep working. You know, I have a letter from Joni, and I'd like to read it to you, if I may. To my brothers and sisters in Christ, well, I don't know quite how to start this letter except greetings in the name of our Lord Jesus Christ. Since my arrest on March 1st, 2001, much has happened in my life, especially my growing faith in the Lord. Years ago, I didn't understand how people went to jail and suddenly became Christians, but now I realize how the Lord must bring us to our knees before we truly see the light. Admittedly, I didn't think so kindly about what is commonly referred to as jailhouse Christians. But until I witnessed with my own eyes what happens to a person when they have absolutely no control over their circumstances, did I really realize that being a Christian is not only being saved, but also understanding that your faith is a growing process and answers are not always revealed in our time, but in the Lord's time. Also, never again will I try to understand what any person goes through until I have walked that mile in their shoes. Prison is nothing like what I anticipated, particularly the people I would encounter. I have said many times since coming here that some of the nicest people I have ever met, I have met here, and some of the wickedest I have met on the street. I'll let you figure out who that might be. When I first came here, that's June of 12th of 01, I was put in the maximum security unit with the most violent offenders, and then after 3.5 weeks, I was moved to the close security unit. This was at the time that my husband almost died in the hospital. For over 2 weeks, I didn't know whether he was dead or alive, because I was not able to call because of certain procedures here. Those 2 weeks were the lowest point of my life. There was nothing I could do but pray and thank the Lord my husband pulled through. That was the first time my husband had been in the hospital since World War II in 1944. Just an aside from that, he's been in there three more times since then. As you probably know, my husband has had several acute asthma attacks since I have been here and has been hospitalized 3 other times. I have never felt so helpless in my life. That is when I truly began to realize that I had no control and had no choice but to get on my knees and pray. I know that many of you have been praying for Richard and his family and for me and my family, and I can't express how deeply that is appreciated. Prayers do work. On February 12, 2002, exactly 8 months after I arrived here, I was called off work as a line server and sent back to my unit. When I walked into the office of the unit manager, there were other staff people there. I had no idea why I was summoned, but I prayed as I walked back, only to find out that I was kept in the close unit by mistake for 8 months. That same day, I was moved to a medium security dorm unit. While in the close unit, I was confined to a locked cell with a bunkie which had its own sink and a toilet. With the exception of work and rec time, you are locked down most of the time. It was not as bad as it sounds, as the room had a window which could be opened, albeit with bars. A small desk and a medicine cabinet, but as most of you know, I don't use medicines, so I had my half of the cabinet packed with all but. It was a very high ceiling, so you didn't have such a closed-in feeling, and you did have the advantage of more privacy, particularly when your bunkie was at work or on your days off or when they were at one of the many program meetings they have here. I don't do much in the way of meetings because most of them are related to drugs, alcohol, domestic violence, anger management, incest, etc., which have no connection to my life outside these walls. I try to focus most of my activities toward Bible studies and selected church services. It seemed apparent to me that they wanted me to be as uncomfortable as possible, but what they didn't understand was that I knew that the Lord had put me there for a reason, possibly to protect me. What Satan meant for evil, God meant for good. I spent the next 12 months exactly, February 12, 2002 to February 12, 2003, in a large dorm with 120 women. This was a temporary shock after being locked in a cell, but after 3 to 4 weeks of adjusting, I managed quite well, even though most of the time I was on a top bunk. You can imagine, just about 6 weeks younger than me, and I'm 59, will be 60 in January. I managed quite well, even though most of the time I was on a top bunk, which at times can be challenging. The biggest problem for me was to have to view constant and overt sexual conduct in the bath area combined with cigarette smoke every time you went in the bath area. Many officers choose to ignore blatant behavior while screaming at others who would hug a sister in Christ to console them during a family crisis. In spite of all the negative things going on around me, I chose to focus on those people and things that would give me the strength to endure. Many of the people I have met here are truly spirit-filled, kind and sensitive, and are trying, and to be the best that I can be, regardless of my circumstances. I will not stoop to a level set by some here, but rather use my faith to be a witness for the Lord. Maybe God chose Richard and I to be put into this circumstance because He knew He would help us to endure. I don't know, but time will reveal His purpose. On February 12, 2003, I was moved to another unit, which is one of the oldest buildings in the farm. Many here have told me the building was condemned a long time ago, and if it wasn't, it probably should be. I had a top bunk in a below-grade small dorm. It did have windows and a good view of the yard, etc., but I was below a sewer pipe that leaked and had to be wrapped with a plastic bag to catch what leaked. The interesting thing about this place is that when they move you out of the large dorms to what is called preferred housing, with one exception, they are the oldest buildings on the farm in a bad state of repair. They call it preferred housing because the rules are not so strict, not because it's nicer. Some girls can't wait to get to preferred housing. For whatever reason, the Lord saw that I would only be there 3.5 weeks. I was called out of a visit, moved to where I am currently, which is called the camp or MCC. I think my 3.5 weeks at the other unit was to free up a needed bed on the other unit until there was room for me at the camp. This unit is where I have been since March 7, 2003, and is the same unit that houses boot camp and the baby unit. Mothers with their babies are allowed here until the babies are 18 months, so it is for short-time offenders. This unit is very clean and nice and somewhat remote from the other units. The section I am in is called assisted living because we have many older people and several in wheelchairs. You have to be screened to come here because of the babies and have no crime against the elderly or children. Most people who have been moved here have had no tickets or hole shots, and not many people fit that criteria. We have our own dining room in a separate yard with picnic benches. We also have a garden club, and I have grown my own tomatoes this summer. It has been a blessing even though we have had practically no tools and must carry our water a couple of 100 feet because hoses are a security risk. We would need an officer to watch us the whole time if we had a hose. I can't speak for anyone else here, but I can honestly say if the door and gate was open, a car was waiting, and I was given a 100-mile head start, I wouldn't budge. Richard says the same thing. The Lord will determine when I leave here. In the meantime, I will continue to be a financial burden to the state under our severe budget crisis. Can't lose our sense of humor. There is a talk of turning this unit into an all-boot camp and eliminating assisted living in the very near future, but we are so short of beds on the farm, there is no place to put us. The oldest person is across from me, and she is 85 and in a wheelchair, and the woman next to me is 78 with a severe heart condition. She is one of the nicest people I have ever met, and many times I will wheel her to meetings or the hospital if I am not working. She is here for a life sentence for self-defense. All she can say is that it was me or him. She came here when she was about 70 years old. There are also other women here who are called gate passers, which means they are minimum status and can do work outside the gate, such as the warehouse where our food is shipped in, or on highway yard crew. I want to add something here, and that's like minimum security. And Joni went for evaluation for minimum security, and before she had arrived there, way before she was ever sent there, the probation officer in Cleveland, Ohio here told her that he was going to be her worst nightmare because of what he wrote to the prison. So when she went for this review, they told her that her problem was that she put liens on people, public officials. And she said, well, I don't have any liens on any public officials. And they said, well, yes, you do. And she said, well, if there are any, could you please produce them because I didn't do it. So they said, yes, you did, and you are in denial. Therefore, your security status will remain the same. So until you confess to crimes you did not commit, you cannot progress. The previous 8 pages of my letter have been to let you know that I am personally okay and that my heart sometimes breaks for those at home waiting for our return. I am a full-time math tutor, which keeps me very busy, but that's a good thing. More than anything, I want you all to know that you are in my prayers. I can't tell you how much heartfelt appreciation I have for you, Caleb and Jack, and all of you that have been so supportive of Richard and me and our families while we are gone. It brings tears to my eyes just thinking about it. Please don't take the fact that I haven't written as a sign of not appreciating all your prayers and things you have done in my behalf. There was a misconception on my part before I got here that I would have a lot of time on my hands, which is far from the truth. But then I didn't realize how our labor keeps this place going. All here have to work, no matter how sick or old. I make $20 a month for a skilled position, but there are people here with physical limitations that only make a few dollars a month. The Lord has blessed me with the ability to teach math, and I thank Him every day. I promise in the name of our Lord that I will keep in touch, and again, thank you for being there when it was needed the most. In the name of our Lord, love, Joni. My granddaughter has some copies that she'll put up here at the head of the tables, and if you care to. God bless you all.
How many people listen to the radio, and ABC has a show called Perspective? Anybody ever listen to that? Okay. Well, Sunday morning when I was getting ready for church, ABC Perspective was on and was talking about this breast implant. This ties in exactly what Jack says about the facts are on the moon. All this money these lawyers won on outrageous claims, it was like millions and millions of dollars that they were settling, and here come to the end of the show, it was all bogus. It was absolutely all bogus. And they just, I'm sitting there, I'm thinking, well, yeah, Jack said that. Yeah, outrageous claim, argument, money. Yeah. And that's exactly, you ought to listen to that sometimes in the morning. It's really interesting. But anyway, I forget how much the industry paid out, like hundreds of millions of dollars. And all the while, the true facts were getting in there saying that, there's no problem. We did blind studies, and there's no difference. Women die with cancer here, women die with cancer here. And here, and you're never going to get that money back from our magistrates, et cetera, et cetera. I just thought I'd throw it out to you. It was very, very interesting how the facts are on the moon. Didn't mean a thing.
Okay, any more announcements? All right. We ended the meeting last week. We were reading from the article in the September-October 2003 Americans Bulletin dealing with that article that was written by Conrad LeBeau on money, banking, check kiting. Anybody have any comments or questions about that since we kind of ran out of time? Okay. Victoria had her seminar this past weekend in San Francisco. It was fairly well attended. Over 40 people came. And she has had a number of people at that seminar that were needing assistance and help, such that usually she'll have like a Monday after the seminar to do tutors, and this time she's doing both Monday and Tuesday. She had a lot of very excellent people at that seminar. People not only from the aspect of just straight patriots coming try to better themselves, but a couple of people from some other patriot groups that were coming there to try to find out what it is that are alternatives. In fact, from one person from a very well-known Northwestern group who has got some problems there that he wasn't sure how to handle. And Victoria has been tutoring with him. Hopefully, he's going to get some remedies for some of the things that he needs to deal with. Victoria called me this morning, Monday morning after the weekend. She was very, very excited. She said she had had a partial revelation over the weekend about potential remedies going along the lines of what we have been teaching and studying, and she wanted to share it with me. And in fact, there's been a number of people I've been tutoring with that have had the same problem, namely that they used either a check on a closed account or a bill of exchange to tender a liability, usually a government liability of some kind or another, like a fine or a cost for court or taxes or something like that. And the government agency had come back, as almost all of them do, a second or third time and said, this instrument is not any good. We are going to give you the opportunity to either pay your liability with a certified check or cash, or we're going to go to the court and move for a contempt order against you for having failed to pay your obligation. Now, there is a number of individuals that are in that stage of proceedings right now that have to deal with the response. And in fact, they are concealed as different kinds of events in their particular case, and yet they all wind up being that same scenario, that the other side has not accepted for some reason the instrument tendered for the payment, and they are testing the party that tendered the instrument, and they're coming back now and appearing to get very vicious and wicked about the fact that we don't like what you gave us. You better fix this thing up or you're going to be in big trouble. I think I talked to this group a couple of months back, and we said that in Sarah Fugate's case down in Florida, which most of you should be aware of what was going on, she was the lady that tendered the bill of exchange on the to the private side of the Secretary of Treasury, dealing with the payoff of the bank mortgage when the bank foreclosed upon the principals, a young couple that had bought Sarah Fugate's property, and Sarah herself was a second mortgage holder on that property behind the bank. And when the bank came in and sued the young couple principals for foreclosure, they also sued Sarah Fugate because if they won a judgment on foreclosure against the principals, that would very likely end up creating a liability against Sarah Fugate. The bank would collect whatever they could on the sale of the property. Presumably, there would not be enough equity to even pay off the bank, and Sarah Fugate would get $0 on her second mortgage. So based on that, but late in the game, after the bank so-called had a default judgment when neither the young couple nor Sarah Fugate showed up, the bank went back to the court and asked for a summary judgment, not just a default judgment. And it was in the summary judgment proceedings that Sarah Fugate came in and used as the defense that she discharged the principal mortgage to the bank by way of her bill of exchange. Now, the only reason that the bank lost that case in the judge's decision is because in an open hearing the bank went into dishonor. It had nothing to do with the note or a ruling on the note. And I'm not suggesting that the bill of exchange or note was not valid. It's very valid. But this court, like so many courts, is not going to rule on the facts of the case, and they're certainly not going to rule on a money issue, which is going to end up in an appellate court, which is going to end up as case law all over America. But Sarah Fugate had gone in and tendered a bill of exchange to the bank in Florida. The bank in Florida came back with an excuse that they weren't the holder, a bank in Texas was, even though they were operating the accounts in Florida. So Sarah tendered a second instrument to the bank in Texas. And on a hearing for the summary judgment, the judge asked Sarah Fugate what her position was, and she said that she tendered payment to the bank in Florida and they rejected it, and so she tendered it to the bank in Texas and hasn't gotten it back. As far as she's concerned, the debt was paid or discharged or the account was closed. The judge looked at the attorney for the bank and said, "What do you say?" And the first words out of the attorney's mouth is, "That instrument's no good." What just happened? It was a dishonor. The bank failed to accept the offer. So based on that, the bank was in a dishonor. And based on that, after some more talking back and forth, the judge ruled against the bank. Now, the judge's ruling was clearly based on the bank's dishonor, and he just told the attorney for the bank, "Prepare an order, I'm dismissing your case, you lost." The banker's attorney didn't want to lose. They never submitted the order. Months later, they came back to court on a new motion from the bank's attorneys to try to reopen it. And the whole issue is the judge had no reason to reopen it. They lost because of a dishonor. The bank's attorney suggested that they needed a reconsideration and maybe even findings of fact and conclusions of law. The judge was not going to issue findings of fact and conclusions of law that could be appealed to the appellate court so that the appellate court would have to explain money to the whole United States world. Not only that, the bank didn't lose the case based on the substance of a note or a non-note. They lost the case based on dishonor, which was equity. And in an equity judgment, the judge did not have to offer findings of fact and conclusion of law. So consequently, that's where it stood. The bank got angry. The bank appealed the case. When the bank appealed the case and it went up to the appellate court, one of two things happened. Number one, the appellate court went, no findings of fact, conclusions of law to base a decision on. So, very sorry, can't help you. Or, number two, the bank raised a new issue. And the appellate court says, we can't hear a new issue on appeal. You got to go back down to the lower court and get the facts put in the record at the lower court. So the bank's attorneys went back down again. Now it's been about a year and a half. And what the bank did is the bank went out and somehow or another somebody must have hit them on the head with a sledgehammer, the attorneys, because they got a little more intelligent. They figured out that in order to prevail over Sarah Fugate, they were going to have to get Sarah Fugate in a dishonor. The way you're going to get her in a dishonor is get her to go in and argue about something that allegedly was probably settled. What they wanted to argue about was whether or not Sarah Fugate's tendered bill of exchange instrument was valid. Now, if you've been following procedure as we've been trying to teach it for a period of several years here, the bank can't go into the court and testify that we believe the instrument is a fraud. After all, the attorney already said that. What it got him was a dishonor which lost the case. So somebody must have hit him over the head or shoved him out the door and brought in a more intelligent liar. And this guy decided that he was going to go out and beat the bushes and see if he could show somebody Sarah Fugate's instrument and see what they had to say about it. So he went to a law enforcement officer at the federal level that worked for the comptroller of the currency on the public side of the Treasury, and he showed him Sarah's instrument that was tendered to the bank and said, "What do you think about this? Is this any good?" And the officer for the comptroller of the currency said, "No, this is a fraud. This is no good." And the bank smiled, the lawyers, and said, "Oh, good. Well, we need you to testify." So they went back to Florida, and they noticed Sarah Fugate by notice that she was being solicited to come to a deposition. And the bank was going to depose this law enforcement officer for the comptroller of the currency and Sarah Fugate with regard to the fact that the instrument she tendered was a fraud. Now, has the court ever ruled on the validity of that instrument yet? No. So the issue has not been adjudicated. We said the bank lost procedurally because of a dishonor. So these new lawyers, or the more educated lawyer, now comes in and says, "Sarah, you're going to come down for a deposition." Does Sarah go to the deposition? Better. If she doesn't, she's in dishonor. If she goes to the deposition and testifies, what happens? She loses, because now she's testifying to the validity of the instrument, which means she agrees that whether it's valid or not is an appropriate issue in question, having testified to the merits. So now what the bank's attorney, who's been smiling, is hoping is that their comptroller investigator is going to say it's a fraud, and they're hoping that Sarah's going to say, "No, it's good." Then there would be a controversy, and they could go back to a judge to get a ruling. And since the ruling will be to the merits of an issue on the public side, which way will the judge in equity decide the case? On the public side, and he will take the testimony of the comptroller of the currency to be the overriding testimony to determine the public disposition of this case. So I chatted with Sarah and a couple other people, and I just shared with her our concepts of the procedures. Now, what is interesting here is that in most court cases, when you have a deposition, in civil cases, what does that usually imply? When are depositions brought forth in civil court cases? For what reason? No, not subject matter. They already got it with the filing of the instruments. Yeah, well, it's immaterial whether they show up or not. If they don't show up, it's a dishonor. They lose on procedure. So it has nothing to do with personam or subject matter jurisdiction. Why do they have depositions and hearings? Who's being summoned? Who are they in the case? Debtors' exams. Civil courts have hearings for debtors' exams. They don't ever have a creditor's hearing. Right? Now, in Sarah's case, what do they need Sarah to become? A debtor to lose. So they structure the proceedings, said the spider to the fly, to come into a debtor's exam and be a debtor. Why do they want her to be a debtor? So that she will agree to lose. Because the court has nothing to do with the substance and merits. It has to do with volunteering. So they want her to come down to the debtor's exam and be a debtor. Very simple. That's what it's all about. The bank didn't want to lose. And they went up on appeal, and that went nowhere because of the stupidity of the lawyer in the first hearing who said that instrument is no good. Now they want Sarah to come into the deposition, which is the debtor's exam, and say, but that instrument is good. Same difference. She will then be the debtor. And they can go back and get a redetermination out of the judge. And pull victory from the jaws of defeat. Now, Sarah did go to that hearing, and there's things going on which are basically great things. But at this stage of the game, I'm not going to put the outcomes of that hearing in this group because these tapes get way, way distributed all the way around. This is a private meeting, and the tapes are meant to be private, but nevertheless, right now, I'm not going to go there in her case, but I introduced her case because it's so obvious that what they're trying to do is schedule a debtor's exam to get her to come in and be a debtor so that the bank can win. Now, I got a call from someone today, and this guy has been going around in circles with the federal Justice Department in a court setting for approximately 2 years. And this case has gone back and forth and up and down, and he did acceptances and returns. Basically, there's two parties in this case. Each party's behaved a little bit differently from time to time, but they're both somewhat on the same page now, and they're both trying to do acceptances. Both of these parties have tendered either bills of exchange and or checks on closed accounts to the United States prosecution to settle and close the matter pursuant to expenses and fines and other things that have come out of the court. And the woman U.S. prosecutor has gone back to these two guys, each individually, and suggested strongly that their tendering instruments were no good. That nobody will honor them. And that she's had it up to here, and if these people do not tender a certified check or cash by a such and such a date, she's going to the court with a motion for contempt and have arrest warrants issued to pick these guys up. What's going on? Testing them for what? How is she setting it up? What is the contempt hearing? Debtor's exam. It's no different than what they did for Sarah Fugate. Just call it by a different name. It's a debtor's exam. So what happens is people tender these instruments and ask for settlement and closure. And the other side keeps testing, and what they do is they go on and on and on to test people to see if they're going to fall into a dishonor. If they don't fall into a dishonor, they're threatened. Then they're either called in civilly for a deposition or they're threatened with a contempt and criminal fines and arrest warrants. But they will ultimately end up before someone taking testimony, and the whole nature of the event is a show cause, which is nothing more than a debtor's exam. So in talking to these guys, or at least one of the two today, I said, hey man, this is straight out of the Sarah Fugate concept. They're calling you in for a debtor's exam if it goes that far. Well man, they may arrest us. So what? They arrest you, what are they going to do? Lock you up forever? I said, it's a show cause, man. If they arrest you, it's for the purpose of taking you before the judge. It's just a little harsher treatment than sending you a letter saying you all come on down for the deposition. So I said, what are you going to do when you get in front of the judge? Okay, the issue for Sarah is, what are you going to do when you get down for the deposition? Don't testify positively to the merits of the issues. What must she do, though? She what? Ask questions and negative averment. What is the purpose of the negative averments? Deny what they are saying. Rebut the false presumption behind their show cause, so that it turns the debtor's exam back on them, so that at the deposition or the show cause, they're required to testify, not you. That's what you've got to do. So the whole concept is you can't do nothing. And your questions are insufficient in terms of evidence to rebut the presumption. It must contain third-party evidence or negative averment that rebuts the substance of their presumption. Now, in the Sarah Fugate case, what was the substance of their presumption? They said the instrument's no good. That's too vague. Is their assumption correct that the instrument's no good? Well, sure it is. Yeah. It's got a witness. First of all, it says it isn't good. Did he lie when he testified? No. So if you don't do something of substance to rebut that position, if all you do is ask questions, the presumption stands. What is the presumption that they're going with that has to be rebutted? Don't tell me the instrument's no good. The answer is yes and no. Well, Sarah is the debtor until the account is closed. That's true if they close the account. No, not yet. So she is the debtor. That's not the assumption and presumption. What is the false assumption? We know the witness is correct, but he's incorrect as far as Sarah's position is concerned. The assumption is she didn't try to settle the case. Oh yeah, she tried all right. She tendered him a piece of paper. That's not the substance of the issue. She didn't pay it. Nobody can pay it. There is no money. That's irrelevant and immaterial. What is the substance of their presumption? She didn't settle according to their satisfaction, but who the heck knows what their satisfaction is? Who even cares? All she's got to do is settle by law. They assume Sarah's going into dishonor. They feel she's in dishonor by their assumption. What is the substance of their assumption? Which she has to rebut. If she doesn't know that, there's no sense for going forward in the case. She isn't going to make it. She could ask any question she wants. That doesn't rebut the evidence of the presumption. She's got to know the answer before she goes in there, or else she hasn't rebutted the presumption. No, it's not that she knowingly forwarded a false document. No, that's not the substance behind where they're coming from. Where'd their witness come from? Comptroller of the currency. Does he work for the Treasury? You bet. Well, then he ought to know. Well, he ought to know, shouldn't he? Well then, if he ought to know, she has no defense because he's an intelligent, knowing witness. She loses. They're assuming that the tender was directed from the public side of the Treasury. That's their assumption. In which case it's no good on the public side of the Treasury. So what she has to do is rebut the presumption that her tender wasn't from the public side, it was from the private side. Oh, doesn't that change everything then? Now, where was their witness from? Which side of the Treasury? Public. Does he have standing, knowledge, character, and capacity to testify as to what's going on the private side of the Treasury?
No.
Then is he a competent witness? No. So all she has to do is rebut the presumption they hold that the tender was from the public side, and then cross-examine their witness, which is testifying the instrument is a fraud, and get him to admit that if the instrument comes from the private side, and he has no knowledge of what's going on the private side, and hasn't investigated the private side, doesn't that lead to presumption and probable cause that his testimony is irrelevant to these proceedings? All she has to do is disqualify their witness by rebutting the presumption. So can't she go into the deposition with the negative averment already executed, the affidavit that says something like, I don't believe that the instrument that was tendered to the bank was an instrument from the public side of the Treasury? If she makes that statement, and she can make a second statement, I don't believe that their witness from the comptroller of the currency has investigated the private side of the Treasury accounts to know whether or not the tender is valid and sufficient or not.
This puts the Comptroller General in a box because even if he does know, he can't admit it. And if he admits it, then it's case history, and then it spreads to the rest of the Toby the slave.
Right. Now, understand, this is a debtor's exam, right? So whoever comes in having to testify at the debtor's exam is the debtor. So she needs to come into this hearing with the negative averments and any other evidence merely to rebut the presumption that the instrument tendered was not from the public side treasury. And she's going to be happy as a lark to come to the deposition because she wants the other side to show cause how this instrument that is not from the public side could be invalid. Who's going to have to testify at the deposition hearing? The bankers or Sarah Fugate? The bankers. So who's the debtor? The bankers. Is she going to argue with them? No. Is she in dishonor? No. If the bankers want to argue that it can't be from the private side, what have they just done? Dishonored, and they're still a debtor. So she's got to go into the hearing not to testify, not to argue, but to reverse the presumption so that the true debtors testify.